Okay, we're live.
Okay, great. Thank you, Catherine. So Judge Wilson, I will turn it over to you. I have taken roll call and we do have a quorum at this point, and I'll certainly note if anyone else joins us. We're just expecting 1 or 2 additional folks at this
Okay,
point.
great. Thank you, Dr. Saleh. And welcome everyone to our regularly scheduled meeting. I appreciate your all's attendance. We do have a healthy docket tonight, but we'll try to move through it as efficiently as possible. First item we have for review is the minutes from the, I guess we'll call the business meeting first for the December 8 meeting, and then we'll move on to the public comments. I guess we can actually take them both at the same time, can't we, David?
Yeah, Judge Avery, sorry, Judge Wilson, you might be looking at the old agenda. I think this.
Oh, you're right.
We are looking at approval of the minutes from February 22nd.
Yep, pardon me.
No problem.
They pull it up. Computer files are like that. So, all right. So approval of the February 22nd minutes. Any changes, questions, additions to them? Sounds like none. If none, then if you could all signify by either a thumbs up icon, a wave, or a yay, please do so, indicating your approval.
Yay.
Yeah. And I apologize, I'm tuning in from my iPhone tonight, so I can't see the big screen and all the faces, so I'll trust
Looks
on
like we're good.
David. Good, very good. Trust on you all to tell me that everything's good. So guideline subcommittee report, Judge Avery.
All right, thank you. The guideline subcommittee met as we do, and we reviewed various topics, and I'm going to turn it over to David and other staff members to go over the individual action items and other items on our list tonight.
Thank you, Judge Avery. The first item on the subcommittee report is a status report with requests for input, and I am going to ask Stacy to take the lead on presenting this first item. Thank you.
Sure. Thank you, Dave. So each legislative session, the legislature reviews the proposed budget for the commission. During the recent review of the FY23 budget, an analyst from the DLS recommended, and the budget committees agreed, that the commission develop a plan for studying the extent to which racial bias is present in sentences assigned through Maryland courts. The full recommendation is detailed in the memo provided for today's meeting. Among other things, it notes that Maryland's sentence population is 72% Black, despite Black individuals composing less than 30% of the state's population. Further, the recommendation notes that the enabling legislation that established the commission states that, quote, sentencing should be fair and proportional, and that sentencing policy should reduce unwanted disparity, including any racial disparity in sentences for offenders who have committed similar offenses and have similar criminal histories. Therefore, the recommendation notes it is within the commission's authority to examine this issue further. The recommendation indicates that the plan is to be completed by July 15th of this year, and that it should identify a structure for the study, available data, a timeline, potential impediments, and estimated costs and resources needed to complete the evaluation. After consulting with the governor's finance office, staff provided testimony concurring with the recommendation and agreeing to provide the requested report by the July deadline. The provided testimony noted that the commission had already begun studying racial disparities at sentencing and had plans to continue that work. Commissioners may recall that in December of 2021, staff completed a preliminary review of sentence disparity using the guidelines data for sentences in 2018 through 2020. Those analyses examine compliance and offense score characteristics by race, ethnicity, and gender. The preliminary results were reviewed by the commission at its December meeting and were presented to the Judiciary's Equal Justice Committee in January. The testimony further explained that based on the results of the preliminary analyses and the feedback that we received, the commission had identified additional analyses of sentencing factors by race and ethnicity for future review. They include an examination by race and ethnicity of the offenses that account for defendants' prior record scores, incarceration rates, average sentences, and compliance by disposition type. So as a next step, the staff has drafted and included in the memo an outline for the required July report. The outline was reviewed by the guidelines subcommittee at its April meeting and is subsequently being provided to the full commission for feedback. The outline notes the preliminary analyses conducted by staff, as well as the planned analyses that I just briefly noted. Staff expects that the analyses of guidelines data will not require additional resources and that the report summarizing the analyses can be feasibly completed by July 15, 2023. The outline also notes limitations of the guidelines data and the resources that would be needed beyond those currently available to the MSCCSP to conduct a more comprehensive evaluation of racial bias for all sentences and not just guidelines eligible cases. Specifically, a comprehensive study would require data for all district court cases, data for non-guidelines eligible court cases, circuit court cases, and data points preceding the sentencing stage, since racial bias is often cumulative. It would also require the involvement of outside researchers. So per the specified requirements, the report to be provided in July of this year will simply lay out the plan for examining racial bias in sentences. The actual detailed summary of the results will be provided in a subsequent July 2023 report. And with that, I will open it up to any input or feedback from commissioners.
Thank you, Stacy. Appreciate it. So that was a good summary. So, this happened, an analyst that's reviewing our budget, just says, oh, what do we know about sentencing and, racial biases? And so that happens from time to time. And so this analyst made a recommendation that the Sentencing Commission should study racial biases at sentencing. And so I was just kind of trying to reiterate where this all came from. And of course, they gave us a deadline of July 15th. But when you read it, it really is more about really more coming up with a more comprehensive plan for how to study biases at sentencing. So what our plan, just to summarize, is to kind of say, here's what the data the Sentencing Commission collects. This is what we can look at. Here's some of the analyses that we've already been working on. A fuller report that the commission can work on can be available within a year from July 15th. But really, if the state wants to study biases at sentencing in its totality, that is a much more comprehensive undertaking that wouldn't be needed. And so we would just basically be laying that out in this report that is due on July 15th. So what we did was we ran this plan by the subcommittee and they thought the outline was suitable. Certainly interested in hearing if any commissioners have any further input at that time. And if not, staff will plan to draft this report and present it to the commission at our July meeting, asking for its approval at that time. And then we will submit it by the 15th. Yes.
Yeah, okay, this is Judge Avery. I just wanted to add that on the guidelines subcommittee, we reviewed the proposed response and made some very small edits. I think that it definitely captures the sentiment that we want to express and the messaging, if you will, that we we support this type of inquiry and we want to be supportive of it with the skill and training and expertise that is brought to bear by our staff. But I want to be clear that no matter the value or importance of the request that is presented to the Sentencing Commission, if it's something that is going to sidetrack our mission or is not clearly within our stated mission, then we have to be very cautious about how we proceed because we establish precedent. And I've said it before, but no good deed goes unpunished. And that applies very distinctly to the Sentencing Commission because we have very highly professional, highly trained staff that deal with data and sentencing statistics, but that the staff is is here to do a job that is prescribed by the legislature. And to the extent that we are constantly asked to bring that expertise to bear on other projects, we are necessarily taking away from our legislative mission. So I just want to be careful. And I think that the messaging here is very good. This is an incredibly important inquiry. It's very meaningful. We support it, but it has to be done in a way that does not, overwhelm the resources of the Sentencing Commission. And in addition, and I don't mean to keep going on, but I just want to kind of convey to the commission as a whole, the issues that we talked about. And that is that this is the kind of research and inquiry that doesn't have to be done by the Sentencing Commission, because again, we deal with guidelines, with guidelines required offenses and sentencing. And this inquiry, which is seeking to identify racial differences in all aspects of sentencing, really goes so much deeper. And it also invokes the questions about systemic racism, which starts, way before you get to trial and criminal charges. So we want to make sure that we're conveying, again, that this is a much bigger project. It's a much bigger question. It should probably be conducted by an executive agency. And, whether it's GOCAP or some other type of justice partnering agency, that would make sense, because in order to get the data and the questions answered in a broad, effective way, you have to go to many different agencies. So all that being said, I want to express support for the statement as it's written. And that it also reflects the consensus from the rest of the Sentencing Guidelines Subcommittee.
Thank you, Judge Avery. I see Judge Lewis has her hand up.
Thank you, David. I concur with everything that Judge Avery said, and I just want to stick a pin in something very important that you're all talking about. There is discussion of sentences in district court, and we just need to be very clear. This commission does not collect any such data.
Right.
Okay, so when you talk about expanse, I don't know if anyone has a true handle on that. I would suggest to you that Prince George's County, both circuit and district, are just coming on to MDEC. We're going to start on it in October. Okay. So not even in a place where you could gather data like you can possibly from other courts and certainly district court. And Baltimore City is behind us. Now, I think, David, you may want to get that projection date of
right.
when lined up to go, but the fact that we're going to start with MDEC in October doesn't mean, that's not our go live date. That's just
right.
Okay. So when you're talking about July of 2023, I don't know that anybody has a true handle, but there are a lot of cases, but I don't even know how you would begin to start categorizing.
Right.
So everything Shannon Avery said about the first part, absolutely true. But I got to tell you, this caveat could swallow the whole thing. I mean, you'd have to have a conversation, and I'll certainly alert Chief Judge Marcy, but it would be further out than 2023 before I think it would even be anywhere in a position
Right.
get a handle on that. But so that just want to make sure that's
Right.
sort of
I
clear.
completely understand that and agree. And really, just to clarify, like our plan would be by 2023, just to say, here's what we can tell you about guidelines eligible sentences.
Okay.
And say, if there's a desire to study the broader criminal justice system, which it seems like that's the intention here, that is going to require outside efforts beyond the scope of the Sentencing Commission. So that's the way we would lay it out in our report. The one on July 15th is really going to be more like, here's what we did, here's what our plan is, and we can do a more detailed analysis on guidelines cases by July of next year. But the broader scope of that is going to require additional, resources, and I think it would be helpful to spell out some of the details that you just laid out about MDEC, et cetera. But basically, we'd be saying that that's beyond really the Sentencing Commission to go to that left. I mean, we as example would cite, there's a study done by the Harvard Law School that tried to get data from a lot of different, entities, prosecutor data, arrest data, et cetera. And they had extreme amount of resources, and they had tremendous difficulty and weren't able to obtain all the level of data that they would hope. I mean, it still had a good study, and I think that's a good structure, but it kind of emphasizes how difficult it is to do this at a statewide level.
Thank you.
I see Mr. Zarimba's hand up. Yes.
Yes, thank you, David. Recognizing the inappropriateness of including the tens of thousands of district court cases in a study like this, maybe as an alternative in terms of potential subsequent analysis, the study could look towards VOPs in circuit court instead, and not, try to digest the great, number of district court cases. And I say that, and again, that might be beyond, what everyone is capable, but there is a section 9 that says potential subsequent analysis. I just, I'm reminded that Judge Karoum comes to us every year at the annual meeting, and he emphasizes the importance of VOPs on issues of studying, sentencing outcomes, especially with regard to race, because 40% of people who are doing sentences are as a result of VOPs. So if there is going to be one other area or that might be included requiring additional data, it seems to me it might make more sense to include circuit court VOP. So at least for one area of cases, which are the cases that are within the purview of the Sentencing Guidelines Commission, we have a complete picture over the course of the life of the case. Because, if you don't include the VOP, there's a large part of the life of the case that is not included within, any conclusions you can make about whether there are any disparities that are resulting in the criminal justice system. So I would just throw that out there.
Yeah, I appreciate that. Okay, well, I don't know that I see any other further input at this time. I appreciate hearing from the commissioners on this topic, and we will be bringing it, back for a draft of the report. We'll be sending it to you in advance of the July meeting. Okay, so I think we can go ahead and proceed to the second item on agenda item 4B on the subcommittee menu, and Sarah Bowles is going to present the discussion of the proposed reclassification of arson first degree. Sarah?
Dr. Soleil, I think David Moon's hand was up.
Yes, it was.
Oh, okay. Did I miss? I'm sorry, I missed that. Delegate Moon, did you have a follow-up question?
Apologies. I just wanted to flag one aspect of that reporting requirement, and that's the sunset on there, which came in at the last second to do an undoing of that law in 3 years. I would also note that in that time, there's a change in gubernatorial administration and some shifting in the legislature. And I had wondered if there was any thought towards legislative action during that 3-year period, and some of these, concepts about, where the appropriate body would be for this sort of a study. If there's some thought towards a strategy, I guess, to not just sort of live with what's going on here.
So I'm Delegate Moon, if I could follow up on that, I'm not sure which, you're referring to, you said the sunsetting, which in reference to?
Sorry, I and maybe I missed the context here because I jumped on a little bit late, but is the reporting you're talking about in reference to the bill that you sent around?
No.
Okay, all right, then I apologize. I'm off the
No, that's okay.
Yep.
We're going to talk about that a little bit later. That's a separate issue items that we will need to report on. Yeah.
Okay.
Yeah.
I just want to put a pin in that because I saw the bill you sent around and.
Okay.
Yep.
All right. No problem. All right. Well, let's then go ahead with the second item on the subcommittee agenda. And Sarah, can you present that for us, please?
Sure. I'll be discussing the memo proposed reclassification of arson first degree. At the Commission's November 10th, 2021 meeting, Ms. Kathleen Murphy, representative for the Office of the Maryland Office of the Attorney General, requested that the Commission review sentences for less common property offenses. This request was made in response to the proposed revisions to the sentencing matrix for property offenses to go into effect July 1, 2022, which reduced the guidelines for most cells in the property matrix. Ms. Murphy expressed concern that the proposed revisions would be reducing the guidelines for some very serious offenses. And because these offenses are less common, their sentences had less impact on the data used to develop the revised ranges. Therefore, it makes sense for the Commission to separately examine their average sentences and compliance rates to determine if they warrant reclassification. The Guidelines Subcommittee reviewed data for seriousness category 3 property offenses at its April 25th, 2022 meeting. And based on its review, the subcommittee voted to recommend to the Commission that arson first degree be reclassified from a property to a person offense. And this memo presents to the Commission the Guidelines Subcommittee's review of arson first degree. Per criminal article section 6-102, arson first degree prohibits an individual from willfully and maliciously setting fire to or burning either a dwelling or a structure in or on which an individual who is not a participant is present. The latter act by definition involves a person, while the former may or may not involve a person. Arson first degree is currently classified as a seriousness category 3 property offense. It carries a statutory maximum of 30 years and or a fine of up to $50,000. It is presently the only crime of violence not classified by the Commission as a person offense. The Guidelines Subcommittee engaged in a robust discussion of arson at its April 25th meeting. And for 3 reasons, the subcommittee voted to recommend to the full Commission that arson first degree be reclassified as a seriousness category 3 person offense. 1, arson first degree is a crime of violence, and it is the only crime of violence not presently classified as a person offense. 2, arson first degree poses a substantial risk of harm to any inhabitants as well as first responders. 3, the statutory distinction between arson first degree and arson second degree clearly contemplates the greater risk to humans involved in arson first degree versus second degree. For comparison purposes, Table 1 on page 3 of the memo illustrates the mean guidelines applicable sentence by offender score for arson first degree and the sentencing guidelines for this offense under various scenarios. The fourth and fifth columns of Table 1 illustrate the current and revised guidelines ranges by offender score, while the sixth and seventh columns of Table 1 illustrate the guidelines ranges if arson first degree is revised to be a person offense. And the eighth column of Table 1 illustrates the guidelines range if arson first degree were revised to be a seriousness Category 2 property offense. Most notably, the guidelines ranges for a first-time defendant would not include probation under any of the revised scenarios. Finally, Table 2 on page 3 of the memo provides a list of comparable seriousness Category 3 person offenses. And with that, I'll turn it over to the commission.
Thank you,
Okay, so,
Sarah.
yeah, so this is an action item.
Correct.
And we do need to vote on supporting the recommendation of the subcommittee for the reclassification.
Yeah, Judge Avery, to make things easier with Zoom, please go ahead and you're welcome to lead the vote.
Okay, thanks. All right. If I can have a motion to accept the recommendation of the guideline subcommittee.
To accept the recommendation of the committee.
Correct. Thank you. Any questions or comments?
Mr. Zaremba has his hand up.
Okay.
Yes, thank you, Judge Age. Very briefly, I think it would be more appropriate, and I understand the concerns with the revisions of the guidelines, and you have offenses that are more serious like arson that may need to have their sentencing guidelines to be looked at specifically. But I think that there are some problems when there is a categorization of something that it's not to reach a result. You know, at the common law, arson was not considered a crime against a person. It was considered a crime against the security of habitation, just like burglary, which is a property offense. All the comparable offenses that it's been compared to involve crimes of violence against persons. Arson does not necessarily require that. We all know that arson only requires the slightest burning of any portion of a dwelling structure.
Okay, but we are talking about first degree arson as
Yeah.
distinguished. So you know, be sure we're talking about the same thing, Mr. Zaremba.
Well, we are, and again, the slightest burning of a dwelling structure. And if you look at the pattern jury instructions, there's no requirement that anybody be present. Just has to be a place where people regularly reside, but nobody has to be present. It's to be defined as a dwelling structure. It could be, and it's in the pattern jury instruction, that it could be, the dwelling can be that of the defendant or a place where the defendant resides. And I can tell you my personal experience practicing as a public defender in Baltimore County for over 30 years, 10 of which as district public defender, that, you know, the vast majority of arson cases that we would see would involve cases in which the defendant actually resided at you know, the dwelling that was the subject of the arson. So again, I think I can only really honestly think of one instance in which there was a case in which the place burned down and the lives of firefighters were, you know, put at risk, as is the example that was cited in support of this change. That was a death penalty case that I tried in sometime 2000, almost all of which first degree arson cases that I was aware of in assigning cases involved, you know, some type of charring to the dwelling house. So it was a first degree arson, but, you know, it wasn't a crime against a person. And so I think, again, it's more appropriate to recategorize this as a property category 2, rather than to change it to an offense against a person.
Anyone else?
Judge Avery, let me just, and this is just as historical note, I was a prosecutor for 15 years, and contrary to Mr. Zaremba's experience, my experience was, though many arsons were committed on a dwelling that the defendant resided in, other people resided in them too. It was usually an act, could be domestic violence, could be family, could be, but it wasn't like that was the only person living in those residences. And I think that's part of the reason that the subcommittee did agree with staff on how to recharacterize. So I'm just throwing that out there for what it's worth.
And I don't disagree, with that characterization. And I apologize if I gave the impression that, in my experience, the defendant was the only person residing. But, much like your experience, Judge Wilson, I think almost all of the arsons that I have seen involve a place where the defendant resided, and there were no charges filed that showed an intent to harm another human being. There was an intent to light a fire within the apartment or the structure at some point.
Okay, any other comments? Okay, Rick Fincy?
I saw Bob Harvey. Why don't we let Mr. Harvey go?
Okay, well, you were first in my line of
Well, that's good to hear that I'm first in your mind.
of pictures. You're the first picture.
I get it. Well, my problem, I said in the guideline subcommittee meeting, I think I abstained on the vote on this, and that was because I wanted to do a little bit of more legal research on some of the things that Mr. Zaremba has brought forward about the common law basis, about the historical basis for why the original sentencing guidelines committee of judges made arson a property offense versus a person offense. I haven't been able to find that answer, but I did do some legal research and found a case, Brown versus State, which apparently is still good law, which I think supports the guideline subcommittee recommendation because of the issue, because first degree arson requires proof of malice, which is unlike second degree arson or lesser count of degrees of arson, which don't require actual malice. My real concern, though, is that is the secondary effect of making this a person offense, which is bringing into play even more harsher guideline considerations in the way of enhancements that really we are effectively being, saying what sentences should be in arson cases by doing this. And so my concern is that we are reclassifying to the point of increasing the range in a way that suggests that the commission's view ought to be accepted by the court, rather than the commission noting statistics and making guideline changes accordingly. And what I'm referring to specifically is the issue of whether fire would be treated as a weapon, to me, obviously, if there is some sort of accelerant or a bomb causes an arson, that would, I think, if we make this a person offense, clearly suggest the presence of a weapon. We also have special victim vulnerability that may be coming into play by making this a person offense. The point is the enhancements increasing the guideline range beyond what historically and statistically it has been for this offense. That is my concern. I'm not suggesting that the subcommittee is wrong, that because of the presence of actual malice, it ought to be perhaps a person offense, but I just think by doing it in this way, we aren't considering all possibilities and all variables that come into play.
All right, thank you, Rick. And looking for the next hand up. Does anyone else have their hand up? You want to just unmute yourself?
Mr. Harvey did, but I don't know if did we lose him? Looks like we may have.
It looks like he
Okay.
got disconnected.
All right, well, I'm bringing the vote, but I'm also going to comment because there's been a question about why this, why first degree arson was classified as a property offense. And I think it's at least the majority opinion on the guidelines subcommittee that is simply, it's an error. It was an error ab initio, as it were. And I think part of the reason why it was in error is because it's in the statute. It's labeled as a property offense by the publisher of the book. So I guess it's Thompson or whatever. We do know that when the way that offenses are categorized by the book, that's not a statement by the legislature at all. It is merely the classification that is put forth by the publisher of the book. And that is likely the reason why this was originally classified as a property offense. It's at least one explanation. And I think that otherwise it's clear that there is a statutory, a legislative conception that first degree arson, as distinguished from second degree, necessarily contemplates the presence and risk of harm to humans, whether they are the occupants of the dwelling or the building, or if it's the firefighters who are responding. So for that reason, I think that is one of the other things that we discussed. I thought I would share that with you. I'll open it up one last time for comment.
I thought Mr. Harvey, I admitted him back. He must be having some connection issues because he was back on for a second and off again now.
Do we still have a quorum without Mr. Harvey?
We do.
All right. Was the motion seconded?
The motion was not seconded. We had a motion by Lisa Spicknell to adopt the subcommittee recommendation. So there would need to be a second on that if that was the
Second.
motion. Okay,
Okay.
Judge Salmon seconded the motion.
All right, thank you. Can we, for all in favor, please raise your hand either physically so we can see you or with your reaction bar, and then I'll let David take the vote. Judge Salmon, just so you know, we can't see you in the
Oh, okay.
frame.
I'm in favor.
Okay, thank you.
And Senator Sidnor, was that a thumbs up? I thought I saw it for a second.
That's fine.
Okay, thank you. Judge Avery, are you voting in favor, I assume?
I am. I have my thumbs up there.
Oh, I don't see it. Sorry.
Okay. Oh,
I see.
it's down. It came down. It's a mystery. Okay. All right. If you're voting against the guidelines recommendation, first off, let's make sure everyone has their hands down or their
Right.
thumbs ups down. And now we're going to take the vote against the recommendation.
Okay. Okay, and then Rick, are you abstaining?
I'm abstaining again, yes.
All
Okay.
right. Are there any other abstentions?
Okay, I think I got everyone, and the motion would carry.
Okay, thank
By a vote
you.
of 8-1 and 1 abstention.
All right, thank you. And thank you to Catherine for the presentation. Was it
Sarah
Kat-
on that one, that's
Was
okay.
it Sarah? I'm
Yeah.
sorry, Sarah, thank
That's all
you.
right. All right, I am going to proceed with the next item. That is the proposed plan for reviewing the sentencing matrix for person offenses. So as everyone here knows, this commission adopted revisions to the sentencing matrices for drug and property offenses. Those revisions will take effect on July 1, 2022, and that was done after a pretty extensive review by this commission. The agreement at the time was to address the property and drug offenses first, and then consider whether to review any potential amendments to the person offense matrix. So the subcommittee discussed this at its April 25th meeting. A review of the person offense matrix would be a much more complex analysis than the primarily descriptive analysis that guided the decisions to revise the drug and property matrices. Whereas the drug and property matrices base offense severity on the offense seriousness category, the person matrix, as everyone knows, factors in additional elements of victim injury, weapon presence, and victim vulnerability. Accordingly, each intersecting cell of the person matrix does not always correspond to the same offense or the same offense-related elements. So, for example, the same intersecting cell within a person matrix could represent two very different scenarios. One could include a more serious offense with no victim injury, no weapon, or no vulnerable victim, whereas the same cell might include a scenario with a less serious offense that involved a permanent injury and a vulnerable victim and the presence of a firearm. So for these reasons, the guidelines subcommittee agreed that the complexity of the person offense matrix warranted further review, and to hold off on considering any amendments to the person offense matrix at this time. The subcommittee agreed with the staff observation that the more complex process will take a longer time than the evaluation for the drug and property matrix, and that we should give time to observe what happens with the revisions to the drug and property matrix. And also that in the interim, the subcommittee in coordination with the staff should come forward with a plan for how to review the person offense matrix, taking in the complexity of this analysis in comparison to the drug and property matrix. So that is the recommendation of the subcommittee at this time. Just wanted to present that as the recommendation and see if there's any discussion on that moving forward. Okay, I don't see any, so I will, that will be the plan to move forward with that, to come forward with a plan to study a plan for how to review the person offense matrix going forward. The final item on the subcommittee agenda is proposed amendment to the juvenile delinquency score instructions. And this is a recommendation to amend an inconsistency between the instructions for scoring the adult prior criminal record and the juvenile record portion of the sentencing guidelines calculations. I'll refer you to the memorandum titled Proposed Revisions regarding the juvenile delinquency scoring. According to the Maryland Sentencing Guidelines Manual, a prior adult criminal record shall not include any adjudication based on an act that is no longer a crime, and that is noted in Chapter 7.1, subsection C4 of the Sentencing Guidelines Manual. The same exclusion, however, does not apply to the scoring of the juvenile delinquency score. Thus, a defendant who committed a delinquent act involving a subsequently legalized offense, for example, the possession of marijuana paraphernalia, would have the offense scored against them, while a defendant who committed the same decriminalized offense as an adult would not have the offense scored against them. The guidelines subcommittee agreed with the staff's observation that there is no reason for treating the scoring of the juvenile delinquency record differently from the scoring of the prior adult criminal record with respect to adjudications based on acts that have subsequently been legalized. Accordingly, the subcommittee recommends revisions to the Maryland Guidelines Manual and the Code of Maryland Regulations. And those revisions are noted starting on page 2 of the memorandum. And they would essentially eliminate the inconsistency between the adult and juvenile scoring instructions. So on behalf of the subcommittee, I present this recommendation for your consideration.
All right, so I'll present that as a formal motion to accept the recommendation. Are there any questions?
I second.
Second, okay. Any questions? All right, all in favor, please raise your hand or put up your hand there. Good. Okay, I see.
Okay,
All right, any opposed? No, don't look at mine.
okay. So no opposition, so that would pass
Right.
unanimously. Great.
I can't get my hand to come down. I'm like putting more hands up there. I'm so sorry.
I didn't know you could
Like,
put, I didn't know you could put up multiple hands. That's
I
huge.
didn't know either, but I'm really like showing up as the boomer here tonight. I don't know. Just ignore me.
I just lowered your, oh.
That's it for the guideline subcommittee.
Okay, great. All right, well, let's, sorry, that takes us then to the executive director report. So I'll just jump in, Judge Wilson, if you don't mind, just move right into that. Keep us moving along there. Thank you for the thumbs up. 4 items to review in the executive director report. First thing, just wanted to discuss, as I mentioned earlier, the pending revisions to the sentencing matrices for drug and property offenses. And as everyone knows, we, effective July 1, we will be adopting those amendments to the drug and property matrix. The Maryland Automated Guideline System and Guidelines Calculator tool will also be reprogrammed to account for the revisions to the drug and property matrices. Since guidelines worksheets are often initiated in MAGs several weeks in advance of sentencing, effective June 1, an alert message will populate when calculating guidelines for an offense seriousness category and offender score combination whose guidelines range will be revised effective July 1. So practitioners will select whether the sentence date will take place on or after July 1, and the guidelines will be calculated accordingly. If the date of sentence is postponed or moved up, the guidelines will be automatically updated to correspond to those in effect based on the sentencing date entered in the guidelines overall sentence tab screen in the Maryland Automated Guidelines System. A guidelines e-news will be distributed to criminal justice practitioners on or about June 1 to highlight the pending revisions and to provide the information I just noted regarding how to account for these revisions in MAGs and the guidelines calculator tool. Then on June 30th, just the day before they officially go into effect, the staff will distribute another email notification to our Google group, which is basically the same distribution list as the e-news, to remind the group of the changes taking place the following day and to provide a link for the revised Maryland Sentencing Guidelines Manual. So that is the plan for the implementation of the upcoming changes, and just wanted to see if there was any questions about those. Okay, I don't see any, so I'll move along. The next item I wanted to discuss was the planned guideline trainings that we have coming up. Also one that we just recently completed on February 9th, and in April 27th, we did 2 online webinar trainings. The February training was intended primarily for court staff and judicial law clerks, while the April training was a sentencing guidelines 101 training that was intended for all criminal justice practitioners, anyone who was interested in attending. And I think it was our most well-attended webinar to date. One of the things that's, as a result of the pandemic, we really shifted to, online training. And I think it's beneficial because it really allows us to reach a broader audience and to get to more people than we were previously with in-person training. So that is one benefit. There are 4 additional webinars that are planned for June, and those will focus on the pending updates to the sentencing matrices for drug and property offenses. These sessions will be held on June 1st, 10th, 13th, and June 29th. So we're making sure we have lots of information out there about the upcoming updates. Anyone who's interested may register for these sessions via links provided on the Sentencing Commission website training page. Additionally, I am meeting with the judges and court staff from multiple jurisdictions and multiple circuits in May and throughout June. I will meet with the First Judicial Circuit on May 19th, the Second Judicial Circuit on May 23rd, in Allegheny County on May 31st, and then the Fifth Judicial Circuit on June 3rd. So lots of opportunity to get to speak with the various circuit courts throughout the state and make sure everyone's aware about these updates. And also I'll be talking about other, guidelines, topics, et cetera. To that note, I also wanted to just share that Judge Avery and I, along with Judge James Green from the District Court in Baltimore City, will participate in the new trial judges orientation update session that is planned for Friday, May 20th. I will speak primarily on the goals and the purpose of the sentencing guidelines and how guidelines can be utilized by judges to help inform their sentencing decisions. Judge Avery will speak about some of the finer details of the sentencing process, and finally, Judge Green was solicited to provide help about answering some of the frequent questions about the application of the Justice Reinvestment Act, including questions about technical versus non-technical probation violations. So I just wanted to express that I appreciate the invitation to speak at the new trial judges orientation, and it's always a great opportunity to introduce myself to new judges and to inform them about the work of the Sentencing Commission and what the goals and purpose of the sentencing guidelines are. So I'm happy to be back with that group.
And of course, we couldn't be more fortunate to have you. So thank you very much, David.
You're welcome. I appreciate that. The last item I would like to speak to about in the executive director report is an update, and that is on the legislation that this commission met to discuss 2 times earlier this year. So there's a lot that evolved over the course of the legislative session. So let me try and somewhat succinctly summarize what ultimately culminated in the action in the legislative session. So I'm referring to Senate Bill 392 and Senate Bill 763. Those were the 2 bills that were introduced during the 2020 session that had the potential to directly affect the operations of the Sentencing Commission. As you will recall, the commission met on February 7th to discuss the first of those 2 bills, Senate Bill 392 and the cross-filed House Bill 412. Those were the bills that were referred to as the Judicial Transparency Act of 2022. This particular legislation combined separate legislation that was previously introduced during the 2020 session. That was from 2020, it was the Judicial Transparency Act of 2020 and the Truth and Plea Deals Act of 2020. And this legislation, Senate Bill 392 and House Bill 412, had 2 distinct requirements. The first was to provide that the commission in its annual report would provide case-specific information for sentences of crimes of violence, including information identifying the sentencing judge. The second main component was that it would revise the definition of guidelines compliant sentences such that a sentence imposed under a binding plea agreement that is above or below the recommended guidelines range would no longer be considered guidelines compliance. As I mentioned, the commission met on February 7th to review this particular legislation. The commission opposed it and submitted testimony in opposition. The commission then met on February 22nd of this year to discuss the second bill. The second bill, which was Senate Bill 763, would have required the administrative office of the courts, with the cooperation of each state's attorney's office, to collect and provide to the Sentencing Commission approximately 75 prosecution-related data points. Now, the original version of Senate Bill 763 also required the commission to publish online the data collected related to prosecutions in a modern, open, electronic, readily accessible format on the Sentencing Commission's website. Additionally, the original version of Senate Bill 763, required the commission to report on the data received from the state's attorneys, comparing and contrasting the practices and trends among jurisdictions. And finally, would have required that at least twice per year, the Sentencing Commission were to publish issue-specific reports that provided in-depth analysis of one or more areas of prosecutorial decision-making, and at least one report of which were to focus on racial disparities. The commission voted at its February 22nd meeting to oppose Senate Bill 763, really to make sure that our opposition remained consistent from the prior bill, because again, this particular bill would have also, in addition to all these additional duties it would have required of the Sentencing Commission, one of the data points was again to publish individual judge identifiers. In the time after the respective hearings for Senate Bill 392 and Senate Bill 763, both bills were amended multiple times. The Senate passed an amended version of Senate Bill 392 that removed the judge-specific reporting requirement and eliminated any revisions regarding guidelines compliant pleas. The House of Delegates chose not to act on the amended version of Senate Bill 392, but instead chose to amend Senate Bill 763 to mostly include the Senate amended version of Senate Bill 392. Senate Bill 763 was then amended multiple times before a conference committee negotiated the final version that was adopted by both chambers and ultimately signed by the governor. On the last day of the 2022 session, the General Assembly passed the heavily amended version of Senate Bill 763. The bill was amended in the House, whereby multiple bills were combined into a new version of Senate Bill 763 that is now titled Public Safety and Criminal Procedure, Collection, Reporting, and Publication of Criminal Case and Prosecutorial Information. It is labeled the Maryland Criminal Justice Data Transparency Act. The amendments remove the reporting requirements that were initially required of the Sentencing Commission, and instead incorporated the reporting requirements for crimes of violence from the Senate amended version of Senate Bill 392. Hopefully this is all making sense. The commission was also required to add a data dashboard to our website to report the additional sentencing details about crimes of violence. This report will be disaggregated by judicial circuit and not by individual judge, as was originally proposed in Senate Bill 392. I will note that the reporting requirements are consistent with the data that are already collected by the Sentencing Commission and are already publicly available. What is new is that we are now required to do this specific report on crime of violence in your annual report, and also to publish that data to a data dashboard on our website. Finally, Senate Bill 763 also includes the creation of a task force to study criminal justice data transparency. That task force will be staffed by the Department of Legislative Services. The task force is asked to develop processes by which prosecutors can collect information and determine what information should be made public and what information should be kept private. And second, to examine any existing policies of state's attorneys' offices across the state related to transparency of data, the charging of crimes, and sentencing. This task force is similar composition, I would say, kind of to like what the Sentencing Commission involves. The Sentencing Commission Executive Director is appointed as one of the members of the task force. The last thing I will note is that the governor's supplemental budget included funding for the Sentencing Commission to complete the new crimes of violence report and the corresponding data dashboard. So the 2022 annual report, which is due on January 31st of 2023, will need to include the new required report by crimes of violence. Additionally, the staff will work to implement the data dashboard requirement on our website, and that would correspond timing-wise with the publication date for the 2022 annual report. So that concludes my report and update on these bills. I'm happy to answer any questions that I can about this. That was quite a involved process, the way those two bills sort of merged together at the end.
David, I appreciate that comprehensive history. And I'm glad that it's kind of recorded in our meeting as history, because it's been a complicated legislative session with the bills and the amendments and changes. And so I think I'm speaking for the entire commission when I just say thank you. I think we all really appreciate the attention to detail that you have had throughout this entire process, and keeping everyone on the commission up to date in terms of what's going on and the effects on the commission. So thank you very much. And to the staff and anyone else who's been involved in this process all along, we really appreciate all the work.
Yeah, I appreciate that. And it definitely has been, our staff has been tremendous. And I definitely want to thank Senator Sidnor for help keeping me in the loop, and Delegate Moon, had separate meetings with them just to kind of make sure the Sentencing Commission we could look out for our interests this whole time as well. And so I think the thing I'm most grateful for in the end is that actually there was funding to do the additional activities that is required of the Sentencing Commission, because that's not a given. So that is certainly appreciated that was included. So I appreciate that.
I laugh a little because I made mention to Dr. Soleil as he came out in support of the commission's position, which was in opposition to my legislation initially, that we were trying to make certain we had the funding. We didn't want to just kind of stick you all with some obligation without the resources that he was certainly saying that were needed. So I appreciate your assistance in this bill as well. So thank you.
Okay, Judge Wilson, I think I can turn it back over to you. At this
Sure.
point.
Thank you, Dr. Slay. And especially with our legislators there, first, Judge Avery is absolutely right that you and all the people that work at the commission are incredible in your willingness to take on new tasks and the competence with which you complete every task that you're assigned. So thank you very much from all of us. And with the legislators in mind who are present, I would just send one word of caution as you work towards issues for next legislative session. And that is, just remember cause and effect. What you see with the Sentencing Commission are effects. We tally what has happened to try and use the data that is accumulated by the commission to root out causes can be very difficult, if not problematic. As we know, the causes that lead to disparate outcomes start very early in life, and unfortunately started decades ago when we talk about guidelines that are somewhat based on prior criminal histories and disparities in socioeconomic status and racial causes that have led people to where they are now in the criminal justice system. So I would only ask some forbearance on some consideration of statistical analyses that you may wish to have, just keeping in mind that what led us to this point started many, many years ago and can't really be accumulated by this commission. But I do appreciate the legislators always being willing to work with the commission, as well as working on issues to try and make Maryland a better place. So thank you all very much. With that, I do want to bring up the remaining 2022 meetings. July 12th, which I believe, Dr. Slay, we are going to be having virtually yet again.
Yeah, so I just wanted to settle that we did agree to, Judge Wilson and I talked about the July meeting is, before COVID, was always a tough meeting because it's, it's summer vacation season and stuff like that. So we thought it was best to continue with the virtual because we had good attendance last July for that. So, and then hopefully we are able to potentially hold a in-person meeting in September. So that's kind of what we're targeting.
So hopefully that will come off without a hitch, which currently, looks good, but we'll have to see what the situation is as we get closer. We can only pray that it does resolve itself. And then December 6th is this year's date for the public comments hearing and business meeting at 5 p.m. And again, location to be determined at a later date. Is there any old business that anyone wishes to bring up? Any new business or final comment or announcement before we close out this meeting? All right, unless you see a hand up, Dr. Slay, because I can't see the big board.
I don't see any other hands up at this point now.
Then listen, again, thank you all for attendance. Thank you for your hard work. And we will see you on July 12th on the big screen. So thank you all very much.
Thank you, everyone. Appreciate it.
Thank you.
Good night, all.
Good night.